Welcome to This Explainer. Today, we're unpacking a truly fascinating legal and honestly philosophical puzzle. We're going to explore the core theme of holding the government accountable when constitutional rights are violated. It's one of those topics that touches the absolute foundation of how a society balances justice, compensation, and raw state power.
Think about it for a second. How do you actually punish a government? I mean, if a private citizen wrongs you, well, the legal system has very clear ways to handle it. But what happens when the state itself, the very entity that makes and enforces the laws, commits a profound abuse of power? Do you just ask them to pay the victim back? Or do you actively punish them to make absolutely sure they never do it again? This massive question is going to frame our entire explainer today, and we're going to look at how courts around the world, and specifically in South Africa, have wrestled with this whole mystery.
To figure this out, we're going to follow a bit of a roadmap. First, we'll look at the Fose case. Then we'll decode what appropriate relief actually means. After that, we'll take a quick global legal tour, examine the case against punishment, and wrap up with the South African context. Let's just dive right in. Part 1. The Fose case, focusing on police brutality and the demand for justice.
Okay, let's go back to 1994. A man named Nthandazeli Fose suffered terrible assaults at the hands of the police in Vanderbilt Park. He alleged that these actions blatantly violated his fundamental rights. We're talking his right to human dignity, freedom and security of the person, and the absolute right not to be tortured. Now, when he sued the Minister of Safety and Security, he didn't just ask for one big lump sum. He actually split his damages based on two entirely different legal theories. On one side, standard compensation, but on the other, a really groundbreaking demand designed specifically to punish the state. Let's break those numbers down. Fose demanded 130,000 rand for common law damages. This is totally standard legal practice, right? It covers pain, suffering, loss of amenities of life, and medical expenses. The whole goal there is just to make the victim whole again, as best as money possibly can. But then, he demanded a separate 200,000 rand for what he called constitutional damages. He argued this second chunk of money wasn't just to compensate him, it included an element of punitive damages meant to actively penalize the state for violating his constitutional rights, and crucially, to deter the government from ever doing it again. He wanted the state to really feel the sting of a financial penalty.
Moving on to part 2. What exactly is appropriate relief? Decoding the interim constitution.
So, Fose's demand basically forced the Constitutional Court into a corner. They had to figure out what Section 74A of the interim constitution actually meant. It stated that anyone whose rights have been infringed is entitled to apply to a court for appropriate relief. But what makes relief appropriate when a citizen's fundamental rights, like the right not to be tortured, are violated? The Constitution didn't exactly hand them a strict menu of options. It left it entirely up to the courts to decide what tools were necessary to protect and enforce these all-important rights. Could appropriate relief mean handing out a hefty fine just to punish the government? This sets up such a fascinating tension. Traditionally, the law of delict, or common law, exists to regulate relationships between private parties. It's there to compensate for harm caused. But constitutional law? It has much, much broader objectives. It aims to vindicate fundamental rights, deter future abuse by the government, and arguably punish state organs that behave egregiously. Fose's lawyers were essentially saying, look, you can't just use standard common law compensation for a massive constitutional violation. You need a more powerful tool. The big question became, should a civil court stick to just compensating victims, or should it step up and punish the government? Let's broaden our view for part 3, the global legal tour. How the rest of the world handles state abuse. South Africa definitely wasn't the first country to face this puzzle. Over in the United States, there are mechanisms like Section 1983 and Bivens actions that actually allow citizens to sue officials for constitutional violations. And yes, U.S. courts do award punitive damages against individual officials. But, and this is key, they strictly prohibit punitive damages against municipalities themselves. Up in Canada, under their Charter of Rights and Freedoms, courts cautiously accept the idea of punitive damages to enforce rights, though they use it pretty sparingly. But then you look at a country like Sri Lanka. They recognize a specific public law remedy for constitutional breaches, but they completely outright reject the idea of using punitive damages against the state. And that reluctance to use civil courts to punish, that's not limited to Sri Lanka. In the United Kingdom, top judges have historically warned against doing this. In the famous case of Rooks versus Barnard, Lord Devlin stated that exemplary or punitive damages are an anomaly. Why? Because they confuse the civil and criminal functions of the law. He made a great point. Giving a civil court the power to punish totally bypasses all those strict safeguards that exist in a criminal trial, like the requirement to prove guilt beyond a reasonable doubt. Just to show you how controversial the whole idea of financial punishment in civil law really is on a global scale, consider Germany. German law absolutely prohibits punitive damages. In fact, it's so strict that their Supreme Court has explicitly refused to even recognize or execute foreign judgments, like those from the US, if they include punitive damages. They argue the very concept of a civil penalty violates their core legal principles and public policy. For them, it's black and white. Compensation is for civil courts, and punishment belongs strict in criminal courts. Which brings us to part 4, the case against punishment, the real climax of this debate.
So, after reviewing all this global jurisprudence, the court had to weigh some massive criticisms against punitive damages. First up, and this is probably the biggest one, is the taxpayer tension. Think about it. Punishing the state financially, that really just means taking money from innocent citizens, right? The government doesn't literally have its own money, it has taxpayer money. Second, it creates an undeserved windfall for the plaintiff, who, remember, is already fully compensated by standard damages. Third, like we heard from the UK, it exacts a punishment without any of the vital protections of a criminal trial. And fourth, there is virtually no evidence that handing out large civil payouts actually deters systemic government abuse. It's just an incredibly blunt and largely ineffective instrument for changing state behavior.
This quote from the Sri Lankan Supreme Court connects directly to that first point, and it really shows how globally recognized this exact fear is. They perfectly summarize the issue, stating that large awards will only increase the burden of the taxpayer. And they went even further, noting that attempting to deter the state by hitting its finances is, quote, hopelessly futile. You simply cannot bankrupt a government into behaving better. You just end up draining the public purse, the exact same purse that is meant to build schools and hospitals.
Finally, part 5, the South African context and why its legal landscape is unique. The Constitutional Court couldn't just operate in a vacuum. They had to apply all this global theory to their own landscape. Because, let's be real, you can't just copy and paste laws between countries. In the US, the whole push for constitutional damages arose because of some pretty strict roadblocks. They have a split federal and state court system and strong sovereign immunity that often protects the government from being sued under common law. But the South African system is fundamentally different. It has a unitary court system. More importantly, it has a flexible, evolving common law, and the state can actually be held vicariously liable for the actions of its police officers. South Africa simply didn't have the same rigid barriers that forced American courts to go out and invent new constitutional damages. So ultimately, the South African Constitutional Court had to make a call, and they ruled that just because you can create a new constitutional remedy under the banner of appropriate relief doesn't actually mean you should. They found that the existing South African common law, which, remember, already awards damages for pain, suffering, and the profound indignity of an assault, was already broad and flexible enough to provide justice to Mr. Fose. Creating a massive new punitive payout just wasn't appropriate because it wouldn't effectively deter the police, and at the end of the day, it would really just punish the innocent taxpayer for the sins of the state.
Which leaves us with a really powerful final thought. The court ruled that handing out millions in punitive damages won't fix a broken police department. It just drains the treasury. But if massive financial payouts don't actually stop state abuse, what will? Does true accountability require better training, stricter criminal prosecutions for corrupt officers, or sweeping political reform? It leaves us to ponder the real limits of the civil justice system in keeping the government in check. Thank you so much for joining me on this explainer. Keep asking the tough questions, and I'll see you next time.